Rodriguez v. United States is a 2015 case. Justice Ginsburg delivered the opinion of the court. A Nebraska K-9 police officer saw a vehicle drive onto a highway shoulder, a violation of state law, so he pulled the vehicle over at 12:06 a.m. The officer questioned driver Rodriguez about his conduct, obtained Rodriguez's license, registration, proof of insurance, ran a records check on Rodriguez, asked passenger Pullman for his driver's license and questioned him about the nature and purpose of their travels, ran a records check on Pullman, prepared a written warning for Rodriguez, called for a second officer, explained the warning to Rodriguez, and returned the documents to the two men asked for, but was refused permission to walk his dog around the vehicle. After the written warning was issued, 12:33 a.m., when the other officer arrived, led his dog around the vehicle. The dog alerted, the vehicle was searched, and a bag of methamphetamine was discovered, and the subsequent federal prosecution resulting in a conviction upheld on appeal. Rodriguez's suppression motion was denied by the Eighth Circuit precedent that dog sniffs that occur within a short time following the completion of a traffic stop are not constitutionally prohibited, as they constitute only de minimis intrusions. A seizure for a traffic violation justifies police investigation of that violation. A relatively brief encounter, a routine traffic stop, is more analogous to a so-called Terry stop than a formal arrest. Like a Terry stop, the tolerable duration of police inquiries in the traffic stop context is determined by the seizure's mission to address the traffic violation and warranted the stop and attend to related safety concerns. Because addressing the infraction is the purpose of the stop, it may last no longer than is necessary to effectuate that purpose. So no longer than necessary, again, in this case. Authority for the seizure thus ends when tasks tied to the traffic infraction or reasonably should have been completed. Our decisions in Caballas and Johnson heed these constraints. In both cases, we concluded that the Fourth Amendment tolerated an unrelated investigations that did not lengthen the roadside detention. An officer, in other words, may conduct certain unrelated checks during an otherwise lawful traffic stop. But, he may, and this comes from Caballas or Johnson, I'm not sure. He may not do so in a way that prolongs the stop, absent the reasonable suspicion ordinarily demanded to justify detaining an individual. Beyond determining whether to issue a traffic ticket, the officer's mission includes ordinary inquiries incident to the traffic stop. Typically, such inquiries involve checking the driver's license, determining whether there are outstanding warrants against the driver, and inspecting the automobile's registration and proof of insurance. These checks serve the same objective as enforcement of the traffic code, ensuring that vehicles on the road are operated safely and responsibly. Lacking the same close connection to roadway safety as the ordinary inquiries, a dog sniff is not fairly characterized as part of the officer's traffic mission. In advancing the de minimis rule, the Eighth Circuit relied heavily on our decision in Pennsylvania versus Mims. Finally, a Pennsylvania case. In Mims, we reasoned that the government's legitimate and weighty interest in officer safety outweighs the de minimis additional intrusion on requiring a driver already lawfully stopped to exit the vehicle. Unlike a general interest of criminal enforcement, however, the government's officer safety interest stems from the mission of the stop itself. Where did that come from? Traffic stops are especially fraught with danger to police officers, so an officer may need to take certain negligibly burdensome precautions in order to complete his mission safely. United States versus Holt and Bank. Recognizing officer safety justification for criminal record and outstanding warrant checks, on-scene investigation into other crimes. However, detours from that mission period. So too do safety precautions taken in order to facilitate such detours. Thus, even assuming that the imposition here was no more intrusive than the exit order in MIMS, the dog sniff could not be justified on the same basis. The government argues that an officer may incrementally prolong a stop to conduct a dog sniff as long as the officer is reasonably diligent in pursuing the traffic-related purpose of the stop and the overall duration of the stop remains reasonable in relation to the duration of traffic stops involving similar. So you got to diligently pursue that. Okay. Similar circumstances. God. The government's argument, in effect, is that by completing all traffic-related tasks expeditiously, the officer can earn bonus time and pursue an unrelated criminal investigation. The reasonableness of a seizure, however, depends on what the police, in fact, do. In this regard, the government acknowledges that an officer always has to be reasonably diligent. How can diligence be gauged other than by noting what the officer actually did and how he did it? If an officer can complete traffic-based inquiries expeditiously, then that is the amount of time reasonably required to complete the stop's mission. As we have said in Caballes, and reiterate today, the traffic stop prolonged beyond that point is unlawful. The critical question then is not whether the dog sniff occurred before or after the officer issues a ticket, as Justice Alito supposes, but whether conducting the sniff prolongs or adds time to the stop. The question whether reasonable suspicion of criminal activity justified detaining Rodriguez beyond completion of the traffic infraction investigation, not heretofore addressed by the Court of Appeals, therefore remains open for Eighth Circuit consideration on demand. And so everyone else joins Thomas Alito and Kennedy. They just join. Alito later dissents by himself. So the only question is whether the stop was otherwise executed in a reasonable manner. I easily conclude that it was. Approximately 29 minutes passed from the time Officer Struble stopped Rodriguez until his narcotics detection dog alerted to the presence of drugs. That amount of time is hardly put out of ordinary for a traffic stop by a single officer of a vehicle containing multiple occupants, even when no dog sniff is involved. The majority's rule imposes a one-way ratchet for constitutional protection linked to the characteristics of an individual officer conducting the stop. If a driver is stopped by a particularly efficient officer, then he will be entitled to be released from the traffic stop after a shorter period of time than a driver stopped by a less efficient officer. Similarly, if a driver is stopped by an officer with access to technology that can shorten the record check, then he will be entitled to be released from a stop for a shorter period of time than an individual stopped by an officer without access to such technology. This is contrary to our prior cases where we have repeatedly explained that the reasonableness inquiry must not hinge on the characteristics of the individual officer conducting the seizure. The majority's logic would produce arbitrary results. Under its reasoning, a traffic stop made by a rookie could be executed in a reasonable manner, whereas the same traffic stop by a knowledgeable veteran officer in precisely the same circumstances might not, if in fact his knowledge and experience made him capable of completing the stop faster. We have long rejected interpretations of the Fourth Amendment that would produce such haphazard results, and I see no reason to depart from our consistent practice today, ... The majority's approach draws an artificial line between dog sniffs and other common police practices. The lower courts have routinely confirmed that warrant checks are a constitutionally permissible part of a traffic stop, and the majority confirms that it finds no fault in these measures. Yet its reasoning suggests the opposite. Such warrant checks look more like they are directed to detecting evidence of ordinary criminal wrongdoing than to ensuring that vehicles on the road are operated safely and responsibly. Perhaps one could argue that the existence of an outstanding warrant might make a driver less likely to operate his vehicle safely and responsibly on the road, but the same could be said about a driver in possession of contraband. Traffic stops can be initiated based on probable cause or reasonable suspicion. Although all traffic stops must be executed reasonably, our precedents make clear that traffic stops justified by reasonable suspicion are suspect to additional limitations that those justified by probable cause are not. A ... stop based on probable cause affords an officer considerably more leeway. In such seizures, an officer may engage in a warrantless arrest of the driver, a warrantless search incident to the arrest of the driver, and warrantless search incident to the arrest of the vehicle if it is reasonable to believe evidence relevant to the crime of arrest may be found there. The majority casually tosses the distinction aside. It asserts that the traffic stop in this case, incident to arrest, in this case, which was indisputably initiated on the basis of probable cause, can last no longer than is in fact necessary to effectuate the mission of the stop. And it assumes that the mission of the stop was merely to write a traffic ticket rather than to consider making custodial arrest. Today's revision of our Fourth Amendment jurisprudence was also entirely unnecessary. Rodriguez suffered no Fourth Amendment violation here for an entirely independent reason. Officer Struble had reasonable suspicion to continue to hold him for investigative purposes. So, Alito dissents. The rule that the court adopts will do little good going forward. It is unlikely to have any appreciable effect on the length of future traffic stops. Most officers will learn the prescribed sequence of events even if they cannot fathom the reason for that requirement. That's all he said.